started. Thanks for your attendance and your participation. And it's very important. These very important matters that we're going to be discussing. No one is even more important than the other. I'm joined by my colleague Marquise Harris Dawson, and we'll be joined by one or two others momentarily. Okay, we're going to open public comment. And there is no general public comment. We do have some public comment on some of the items, though. So we're going to close public comment. And why don't we call the first item?
Item number 1 is a City Attorney and Bureau of Contract Administration reports and ordinances relative to amending the Los Angeles Administrative Code to allow the Office of Contract Compliance to more efficiently administer equal employment practices, affirmative action, non-discrimination practices, equal benefits, first source hiring, service contract worker retention, and living wage.
Okay, before we hear from the City Attorney and the Bureau of Contract Administration, let's have some public comment. We have Ada Camacho and Tim Maddox on item 1. We'll take your testimony at this time.
Okay. Good afternoon, City Council members. My name is Ada Camacho. I'm an organizer with SEIU, USWW, Airport Workers United. The living wage amendments you have before you today have been assembled through years of input from LAX stakeholders such as SEIU, Unite Here, and LANE, which is Los Angeles Alliance for a New Economy. The amendments strengthen the enforcement of the living wage ordinance and close various loopholes that have undermined the policy's intent. They also adjust wages and health benefits upwards to better keep up with the true cost of health care and living expenses. We understand that in the light of the debate that was had last year around raising wages for thousands of Angelenos and the raise to the minimum wage that the governor signed 2 weeks ago, that we may need to further adjust the living wage. However, we feel that the provisions before you should not be held back while you properly discuss further adjustments. During the minimum wage discussions, there were several issues that needed more time for the committee to investigate, such as sick days and enforcement. These were dealt with separately as the motion made its way to the mayor's desk. In those instances, the committee elected to allow the policy to continue while other issues were handled at later meetings. We ask that you approve the motion today and handle any outstanding issues at later meetings where stakeholders can weigh in. Thank you.
Thank you.
Good afternoon. I'm Tim Maddox, and I'm with SEIU USWW, United Service Workers West. And we're here today. I'm an LAX worker. I've been working at LAX for 21 years now. And we fought long and hard for our standards, lifting the wages and improve the standards here at LAX. And LAX workers, we have to go through a lot. 10 years of background check, clearances with badge, LAWA, Los Angeles World Airports, also customs and immigration. As LA workers, we not only have to deal at one of the busiest airports in the country, but we also have to deal with the unexpected. We have to deal with the stress of the busy airport. We also have to deal with the shooting like it happened at Terminal 3. And also infectious diseases that come often, like as we had with the Ebola scare and also the swine flu outbreak. The other thing, airport workers have to pay from $660 to $900 a year for parking. Now, I guess you see why we're asking that you move to pass the living wage ordinance increases. We thank you if you do that today.
Okay, thank you for your comments, and I want to thank you all for your input and your involvement. Sticking to this. I know it's been a long time coming, but we are committed to doing the right thing and to making sure that our policies align with our philosophies. And so let's ask the City Attorney and the Bureau of Contract Administration to the table. So before us is a challenge to more effectively administer equal employment practices, affirmative action, non-discrimination practices, equal benefits, first source hiring, service contract worker retention, and living wage. Cha-cha-cha. Who'd like to go first?
I'll go first just to introduce myself. I'm Valerie Flores with the City Attorney's Office, and to let you know that John will be delivering the report, John Reamer, who's head of Bureau of Contract Administration. We did confer with BCA throughout this process. It's been very collaborative. John's one of our favorite clients. So. Anyway, go ahead, John.
Okay, Mr. Reamer, please. You're no stranger to this committee, and we appreciate your work on behalf of the citizens of Los Angeles.
Thank you, sir.
Proceed.
John Reamer, Bureau of Contract Administration. I'm going to try to live up to the words that are being spoken. We have several ordinances that deal with our contract-related issues, as well as the conditions for workers that are working under service contracts, be it lease agreements, license agreements with departments of the City of Los Angeles. We've gone through the Public Works Committee in doing so to line up what has been stated earlier, a cleaning up, if you will, of our ordinances so that they are more efficient as it relates to our administering them. They are clear and clean so that both businesses as well as employees can understand what to expect and the working conditions at any given department. In doing so, at the last meeting we were asked to go back and take a look at some areas which we did, and we wanted to bring those before you today. Recommendations dealing with compensated time off. There was a concern that there was not clear language in the ordinance amendments that addressed compensated time off as it relates to businesses that had existing policies. There was also a concern as it related to the individual employees dealing with health care concerns. If someone already had health care that was provided either by a spouse or, let's say, a parent, would they be allowed to be given an exemption from that? And we've had dialogue, and we want to submit, in addition to the ordinance amendment language that has already come forward, some additional recommendations that both business and our office are fine with, all parties seem to be good with, and we believe that it will clearly communicate the council's intent with respect to the ordinances and the workers that work on them.
Can you touch on some highlights of that, those revisions?
Well, yeah, one, with respect to the health benefits, we're asking for language to be removed under a particular sentence that says that employee is not allowed by that plan or the employee's plan to obtain benefits under both plans, even on a coordinated basis. The concern that existed was, let's say you have an employee that has a special circumstance, and the plan that they had, be it through a spouse or through a parent, provided them certain medical care that they could not get if they were working for an employer under living wage. They would come to the designated administrative agency and present to us. And this is very similar to what the city has in place, where if a city employee has health care that's provided for them through a spouse or a significant other, then a waiver would be given. The language previously would not allow that to take place. The employer had to provide health care to every employee. There was not an opt-out unless there was an out-of-pocket case in point where you had to pay additional monies above and beyond what I'm going to refer to as an allowance that's offered through the living wage. So what this would do is this would give the DA the opportunity to say, okay, yes, you're covered. You do not have to receive health care from your employer, but you will not receive compensation, because under the opt-out, what would happen is that the employer would not only have to pay the base rate to the employee, but they would also have to add to that the equivalent amount in a dollar rate to the employee as well. So this will not be any increase in money. but it will give the employee and the employers the flexibility, if you will, to maintain a health care package that they have through, again, a family member or significant other. The concern over the compensated time off had to deal with whether or not someone is able to roll over time, and if you were given a certain number of days, compensated days off, and you didn't use them all, did you have to, or would the employer have to pay them out? We have put language in here that clarifies through our rules and regulations that we will work with businesses if they have what we see as a reasonable policy, one that's going to be beneficial to the employee, then it's something that we will be willing to consider. So the additional language that we're wanting to submit to you today helps clarify that. And we would also ask that you would instruct the city attorney and the CLA to work with us to come back to you at a given time. Language that continues to address the fact that we now have 3 wage ordinances in the city of Los Angeles. We have the minimum wage ordinance, and we have the hotel ordinance, and we have the living wage ordinance. It would be very beneficial for all parties involved to bring these into harmony with one another. I know that it's been a desire that you've expressed, and we would just need direction to move in that direction.
Okay. I think we definitely want to see some uniformity and some consistency across the board, and hopefully that can happen sooner than later. I imagine that won't occur, though, until another year or so, which will give us time to work those differences out. Anything, Madam City Attorney, to add?
No, I believe Mr. Reamer covers all the amendments that we're proposing that are additional.
Mr. Dawson? Okay. Again, for the audience, these are technical changes. They will be coming back to the council for final approval, so you will have an opportunity to weigh in. But without objection, we're going to recommend that the committee concur with the Public Works Committee and their report recommendations and add the following additional amendments to recommendation number 5. Under C, section 10.37.2, subsection B3, to the DAA, and refresh my memory again, DAA?
Designated Administrative Agency.
The designated administration agency may follow an employer's established compensated time off policy to remain in place even though it does not meet these requirements if the DAA determines the employer's established policy is overall more generous. Section D, section 10.32.2 B3V, to after an employee reaches the maximum accrued compensated time off, an employer shall provide a cash payment once every 30 days for accrued compensated time off over the maximum. An employer may provide an employee with an option of cashing out any portion of or all of the employee's accrued compensated time off, but the employer shall not require an employee to cash out any accrued compensated time off. Compensated time off cashed out shall be paid to the employee at the wage rate that the employee is earning at the time of cash out. E, section 10.37.15E, 2. Nothing in this article shall limit the right of the DAA to waive the provisions herein and respect to and at the request of an individual employee who is eligible for benefits under a health plan in which the employee's spouse, domestic partner, or parent is a participant, or subscriber to another health plan, I'm not striking that out yet. An employee who receives this waiver shall not be entitled to the hourly rate without health benefits pursuant to Section 10.37.2. F. Section 10.37.2B4 and Section 10.37.2C3.4. An employer may not implement any unreasonable employment policy to count accrued uncompensated time off taken under this article as an absence that may result in discipline, discharge, suspension, or any other adverse action. And G, Section 37.2C3.1 and 10.37.2B3.1.2. An employee must be eligible to use accrued uncompensated time off after the first 90 days of employment or consistent with company practices, whichever is sooner. And we will add the following additional recommendations: to instruct the Bureau of Contract Administration, with assistance of the CLA and City Attorney, to report back with a comparison list of all living wage, minimum wage policies in Los Angeles, and to provide options going forward to better align the various policies and ensure that no workers are paid below the citywide minimum wage rate. Okay. I'm glad someone understood what I was reading. No, we think these are important steps to take to align our policies and to make sure that employees are getting the benefit of programs that are designed to assist them. So, thank you.
Thank you, sir.
We're going to move on now to item number 2.
Item number 2 is a Los Angeles Department of Convention and Tourism Development, CAO and CLA reports, and CAO and CLA to further report relative to the modernization and expansion of the Los Angeles Convention Center.
Okay, I think we have the CLAs in the house. Modernization of the Convention Center is a top priority of this committee, and we appreciate the efforts that CLA's office and CAO's office is doing to bring that into reality.
John Wickham with the Office of the Chief Legislative Analyst. Just a quick update on the conventional financing side of the project. The architect Populous that was selected in the design competition has begun work on the conceptual design. As you remember, in that design competition, really the idea was to try and identify the best architect to work for the city. And that selection was made, and now Populous is going back. They're working on 3 different approaches to the design. They will have meetings within the next week or 2 with stakeholders such as hotel operators and event managers, organizers, city family, council members, absolutely, to get feedback. One of the key issues that has come up since is the concept of, and it's always been there, is the concept of contiguous exhibit space or contiguous exhibit experience. And so Populous is very much...
We don't have now.
We don't have now. There's a big gap between the South Hall and the West Hall. And so we really are looking at ways to strengthen that connection, whether that's a lot of exhibit space that connects the two or other ways to make sure there's a continuous experience between the two. So Populous is working very hard on that design. It will come in early May. It will come down to a single design that they will then pursue refined design opportunities on. And so that work is part of the conventional approach. And concurrent with that is the DBFOM approach that the CAO will talk about. There are things that are concurrent with both of them, such as the CEQA analysis Bureau of Engineering is moving forward on hiring a firm to do the required CEQA analysis that will be part of both of the projects. And there is a cost estimator that the CAO is working to bring on who will estimate the costs in both projects. And so at the end of the day, when this comes back to you, you will have an apples to apples comparison of the different financial models, the different opportunities in front of you, so that you have a full slate of information available to make a good decision. So I'll turn this over to CAO for their.
Thank you.
Hello, Corin Crawford from the CIO's office. On the DBFOM approach, that work right now is underway, and at a high level, the work involves what we talk about 3 core chunks of work. The first is a basis of design. It's architectural services. So our consultant, Arup Advisory Incorporated, hired as subconsultant the design firm HOK, the architectural firm. And
stadiums and convention centers.
Indeed, yeah, with that experience. And so HOK's task is to provide for a design working in collaboration with CTD and CLA and BOE that demonstrates the architectural viability of the general layout that we proposed within the DBFOM analysis. That includes principally a convention center taking advantage of contiguous space to the greatest extent possible, as well as thinking about what components of a convention center make sense to go vertically to provide for the 9 to 14 acres of developable mixed-use development that was conceptually discussed in our original report. So their scope of work is really to demonstrate whether or not that's viable to the extent that that's viable, given the architectural requirements, the requirements for a convention center, which we hear from CTD, and other stakeholders that we kind of work collaboratively with to make sure that the convention center is the top tier facility and meets all the requirements that the city requires. So that's the basis of design component, and that's begun. That started the same week that the populist work got started during the week of March 21st, with our first kickoff meeting on March 24th. The second piece of work within all of that is market sounding or market feedback. We are issuing an RFI this week, looking to get it out today, end of the day today, which goes out to solicit feedback from the investment community. These would be investors who are infrastructure investors or, quote unquote P3 investors, real estate investors, and looking to get kind of a real world picture of the level of interest of the level of market interest for this type of project. That will inform the business case, which is that will inform the overall business case or the financial feasibility study, which is the third component of the work. That component is really driven by taking as inputs the basis of design and the space afforded with that, as well as the market feedback to make cost projections. And so that feasibility analysis looks at both pathways. It looks at the traditional path and informs a cost estimate of that, and the DBFOM path and the design that HOK produced as a reference design. It's not a final design, but it's just a reference design, a proof of concept design, which provides the basis for the cost estimate. The cost estimate takes a cost of ownership approach. We often talk about life cycle costs within all of that. The city as an asset owner is concerned with optimizing the costs over the useful life of an entire asset. So a life cycle cost approach takes into consideration the cost to design, construct, operate, and then maintain the facility over the useful life. So it looks at what those two costs for the traditional approach as well as the DBFOM approach and makes a comparison. In terms of progress to date, as I mentioned, we had several kickoff meetings. We've had several design meetings with the architecture firm. We're jump-starting the market feedback, and next steps are to start to do the stakeholder, similar parallel process of stakeholder feedback with the reference designs that the traditional approach is taking, and to produce the financial model and analyses.
Good. Well, I'm excited. I think this is an exciting level of cooperation and collaboration as we look at the conventional approach and the P3 approach. And so I appreciate the efforts undertaken so far. Let me just be clear, though. The analysis will include financial models for both conventional and P3. Is that correct?
Yes.
That's the intent. And will the business plan include an analysis of both conventional financing and the financing for the P3?
Yes.
The business plan? Great. And are state EIFD or CRIA programs available for financing, or do we know yet?
So EIFD potentially could be. If you do an EIFD, that would fall under a P3 approach. And the reason why, as you full well know, is that if you were to do some form of, redevelopment-based or redevelopment 2.0 based analysis, right now the city as an owner doesn't pay property tax. And the ability to issue some form of tax increment bonding is based upon property tax. The way to approach something like that would be to, through a P3 procurement, do some form of ground lease structure or long-term agreement that with a private entity that would pay possessory interest tax. Possessory interest tax is equivalent to property tax in a ground lease type of structure. So that possessory interest tax that the private party would begin to pay would form over time as the property gets developed a new assessed value, and the incremental property tax from that assessed value is the income stream which provides the basis for that additional form of finance. Within the DBFOM analysis, we can look at and likely some of the proposers in that, should it go forward, obviously, but just hypothetically, some of the proposers might propose that approach as a component of their financial plan. So certainly we can look at that.
Okay, well, appreciate the update on both approaches. I think we're proceeding as we had envisioned in parallel until we are at a point, I think, what's our timing, May, June, for a final report?
Yeah, the final report, the proverbial clock started on March 21st, so the 90 days would be June 21st, and then followed by, that's when the reports are completed, and then followed by calendaring and the logistics of getting it in front of the council and the committee to discuss it.
Okay, well, we look forward to coming to the committee first before we go to council.
Indeed.
We appreciate that.
Committee and then council.
We're going to then, thank you, gentlemen, for the report. We're going to instruct the CAO and CLA, and with assistance of the BOE and CTD and other departments as needed, to report to the committee by June 28th, 2016, concerning expansion and modernization of the LA Convention Center, and with the final business plan and financial models for both a conventional project and a P3 project, including options and supporting analysis. I think that's what our initial plan was. The conventional financing model discussion should consider several options for financing the project, including, but not limited to, the following. The potential for incremental general fund revenue from signage, naming rights, hotel development, and retail development, and whether and how the Community Revitalization and Investment Authority structure can be utilized to finance the proposed development. A financial analysis under both the DBFOM and the conventional municipal financing model should provide a comparative discussion on general fund impact and debt capacity impact. And so with that, gentlemen, thank you for your reports, and that will be the order.
Thank you.
We'll be holding it until in committee. Yes.
And Councilman, you and your committee and the council had asked that we report back every 30 days, so we will have another report back for you in early May.
Great. Thank you. All right, we've been joined by Senator Gil Cedillo. Just in time for our last item. Item 3, Mr. Clerk.
Item 3 is a CAO BCA reports relative to an implementation plan and resource requirements for an Office of Labor Standards to enforce the minimum wage and address wage theft.
Let me clarify, I think we want item 2 to go to council. That's going to go to council. We're not going to hold it here, it's going to go to council. Yeah. Yes.
It doesn't appear that the title really matches the report. The report talks about ordinances, and the title talks about an implementation plan.
All right, what should the title, how should the title read?
There's a Brown Act title, well, it should probably say report relative to technical, ordinances making technical changes to our ordinances. I'm not sure that they should notice to the public in order to satisfy the Brown Act.
Okay, so what's your,
It would be better practice to either continue this with a different title or send it, I guess you could send it to council with a different title that explains what it was. They would also need directions as to what council wants. That would be directions here.
I don't know if that's necessary, given that the discussion with respect to minimum wage and wage theft amendments, right? And the Bureau of Contract Administration seems to be something that, if you took notice of that, would be included in something about an implementation plan of the minimum wage and wage theft act, or whatever it is that we're doing. So it seems to be within it.
It's just my opinion. The chair's free to override.
I think we'll proceed. We do appreciate your guidance on this. So item 3, can we, I guess, who's up? BCA is always a friendly player.
Afternoon, Chairman. John Reamer, Bureau of Contract Administration. Council member, it's good to be back at the table. And I would say, yes, I would agree. This is in line with our efforts to implement the city's minimum wage and wage theft issue. As we know, will be embarking upon a minimum wage in the city of Los Angeles for the first time come July 1st. And the council put together 2 ordinances, one to govern a minimum wage and also the implementation and enforcement of it through an Office of Labor Standards. Ours has been, the Bureau of Contract Administration, to go through and begin the process of building the foundation to launch this and to launch it effectively. As we've gone through and looked at the ordinance in conjunction with partners, and especially the Office of the City Attorney, what we bring before you today are some items to consider to enable us to more effectively administer the ordinance. So what I can do is I can walk you through these, and just to say what we have done is we have reached out to members of both the labor and business community just to share some of our thoughts and concerns. We believe that they will be very effective in making sure that our ordinance is fair and equitable, but clean in the administration of the process.
Okay, that's important. Yes, if you could outline some of the major provisions, it would be helpful.
Not a problem. Under the minimum wage ordinance, I'll begin with that first. Things that we would like for the council to consider would be to add a definition of wage that clarifies that wages are defined by the state labor code. We would also like to change the announcement date as it relates to the annual increase from January 1 to February 1. That allows us to get the full increase of the CPI for the previous calendar year. We would like to remove the term learners to avoid any confusion that the state definition of learners has. It's a much broader range with the state, but we believe that removing just the term learner will keep us in alignment with council's intent to have a specific group. There is a desire to add the exemption for employees holding transitional jobs, which was discussed. We want to clarify the size of a new business as it relates to when that will be determined for the business's first pay periods. If it's a new business and they're trying to establish whether they're a small or a large business, we'll use the first pay period to do that. We'd like to clarify that the first 5 years with respect to the deferral wage rate for small businesses will remain in effect. So if you start off as a small business, then for the entire 5 years you will be viewed as a small business. And then also to clarify that for a nonprofit organization, if you are given the designation as a nonprofit, but for some reason you lose that status, then you must comply with the appropriate wage. So that's language that we would like to have considered for amendment under the minimum wage ordinance. Under the wage enforcement ordinance, we'd like to change the name to the Office of Wage Standards. We'd like to add language that...
From wage enforcement?
No, right, in the ordinance it reads the Office of Labor Standards.
And you want to change the wage standard?
Yes. We'd like to add language that requires employers to notify existing employees of the minimum wage to ensure that all employees are informed. We'd like to clarify that the city shall have access to all business sites and may interview any relevant witnesses. We'd like to change what's identified as a notice.
Access to all business sites.
Yes.
Which sites are you talking about?
Well, it may not just be the location where the infraction has occurred. It could be a main office, so we just want to clarify that. We want to change notice of determination to notice of correction. We'd like to change procedures for service of a notice of correction to personal service or registered mail so that the city can document that an employer received the notice. We'd like to add language that establishes a mechanism for settlement discussions that will enable issues to be resolved more expediently and before a formal hearing process. The ordinance currently addresses a formal hearing process. We're believing that if we can have conversations prior to that, it might expedite solving the issue and getting monies to the employee. We'd like to change the penalty due to an employee from $100 for each day to up to $120 for each day, and establish criteria including the extent of harm caused by the violation, the nature and persistence of the violation, the length of time over which the violation occurs, the frequency of past violations, actions taken to mitigate the violation, and the financial burden to the violator. This change is more in line with legal precedents, and it allows flexibility for a penalty that's appropriate for each violation. We're believing that a small business that did not have any idea, they just did not know, they violated something that clearly isn't as egregious as a business that clearly did know. We want some latitude. The $100 penalty with the language that currently reads gives us no latitude. The up to does provide that latitude. We'd like to remove interest. An employer must pay on unpaid wages and penalties. This will remove a time-consuming administrative aspect that will delay collection, and that's the other reason why the $100 a day has gone to $120. It takes into consideration the interest piece that we're asking for consideration to be removed. The last thing that we pinned for you was we'd like to add a penalty of up to $50 per day payable from an employer to the city. when wages have been withheld from an employee. This will provide an additional enforcement tool and is consistent with San Francisco's fees and penalties. There are two other items that I'd like to add that are not pinned here with respect to consideration. The ordinance speaks to being able to engage on behalf of employees with respect to filing a civil action. We just like to clarify that real specifically as it relates to authorizing the city to file a civil action on behalf of employees to facilitate the collection of unpaid wages and penalties, and then also give direction to the city attorney to make any additional changes to this ordinance to effectuate these changes that we've brought before you.
All right, thank you. One of your recommended amendments is to remove the interest an employer must pay on unpaid wages and penalties.
Yes.
Noting that this will remove time-consuming administrative costs. Shouldn't the affected employer be responsible for paying this interest on unpaid wages?
No, the employer will. We're referring to the time administratively our staff will go through in calculating what these interest payments will be. That's why we believe going from $100 a day per violation for the employee to $120, it's a good exchange. It's clean, it's upfront, and that is still a penalty, if you will, that will go to the employee, and it does not go to the city. It still goes to the employee. There's graduation there based on, again, egregiousness, but it gives us
Willful.
yes, most certainly. But it gives us a lot of latitude, and we're believing that it will be a tool that we can use to help expedite, quite possibly facilitate getting the employee compensation.
And what role does education play in this, educating the employer and employees?
What's part of our implementation plan is a partnership with industry experts. We've just closed out an RFQ process that we had in place where we received statements of qualifications from many community-based business organizations to partner with us to work toward reaching out and informing and educating both employers and employees as it relates to the ordinance, what's expected of an employer, what's expected of an employee. You hit the nail on the head, Council Member, that outreach is critical. We want to tell as many as we can, as early and as often as we can, understanding, however, that we probably won't catch everyone. And after a complaint is issued to our office, we'll vet it to see whether or not there's merit, and if we believe that an investigation is warranted. And if we find that there is, and part of that investigation uncovers that this was some business that they weren't trying to harm or hurt the employee, they just didn't know. And the reality that we're facing right now is we have the state increasing the minimum wage, the county increasing the minimum wage. We are leading in increasing the minimum wage, but a number of businesses that are calling now are confused as to what they pay where, which one. And so we recognize that, and our investigation will help uncover that. It does give us an opportunity to really identify, and we believe this is the council intent, those businesses that are not doing what they should versus those businesses that want to, they just didn't know.
No, I'm satisfied that the $50 fine and the discretion given up to $120 will provide us an opportunity to make this more efficient as opposed to what you're telling us is a more cumbersome approach with the interest. And it gives range for those who are executing this to acknowledge that not one size fits all. And that in the business community there are some bad actors, and then there are others who may simply not know misfeasance, difference between malfeasance, and there's a range for that. So I'm satisfied with it. Okay. Made it better.
Okay, we've got, thank you, Mr. Reamer. We've got one card on this subject. Mr. John Howland, CCA.
CCA. Thank you, Mr. Chair. I'm John Howell with the Central City Association. I've been before you numerous times saying that CCA supports enforcing wage theft laws and holding accountable those people and businesses who steal from their employees. Wage theft is a crime, and also it puts those businesses that engage in wage theft at a competitive disadvantage over the lawful actors. I've had several discussions with John Reamer from BCA, and I want to thank him and his staff for their work on this. And these amendments have generally fit in line with what we've been asking for and requesting. We've asked that these laws be aimed at deliberate acts of wage theft and not at businesses that make honest or other clerical errors. BCA's report lists a number of changes that give the Bureau more discretion and more flexibility to negotiate and settle cases, and it raises some penalties where a stronger approach is needed. We support this approach, and we thank you, Mr. Chair, for your question on educating employers about this, and Mr. Cedillo for your recognizing that this isn't a one-size-fits-all situation. So we're supportive of this. Thank you very much.
Thank you. Well, I think we are all trying to be responsive and to be collaborative and to be effective, and that's ultimately what we want to occur. So, without any objection, we're going to I'll move to that we concur with the Budget and Finance Committee report recommendations and adopt the recommendations in the April 14th BCA report. Okay. Yes, we'll include that as well. Okay, is there any other business? Any other thing in this, Mr. Singer? Okay. If there's no other business before us at this time, this meeting is adjourned. Thank you.